Hi, this is Riley versus California, a very important Supreme Court case, Fourth Amendment case, decided in 2014. The question was as follows: is a warrantless search incident to an arrest of digital data stored on or accessible from one's cell phone a violation of the Fourth Amendment? The court answered the question in the affirmative. Yes, it is a violation of the Fourth Amendment. David Leon Riley was arrested in the San Diego area. He was identified as a gang member. Police seized his cell phone incident to an arrest, and without a warrant, they searched the digital contents of his cell phone. They found evidence of him being involved in a shooting of another gang member. He was, based on that evidence and in conjunction with additional evidence, convicted of this fatal shooting of a rival gang member and sentenced to prison. He appealed, trying to suppress evidence from his cell phone, claiming that the police needed to obtain warrant prior to searching the digital contents of his cell phone. Now, Chief Justice John Roberts, who wrote the opinion for the unanimous court, stated that warrantless search exception following an arrest exists for the purposes of protecting officer safety and preserving evidence, neither of which is at issue in the search of digital data. The digital data cannot be used as a weapon to harm an arresting officer, and police officers have the ability to preserve evidence while awaiting a warrant by disconnecting the phone from the network. Justice Roberts went on to say that cell phones are mini computers that are filled with massive amounts of private information, which distinguish them from traditional items that can be seized from an arrestee's person, such as a wallet. The court also held that information accessible via the phone but stored using cloud computing is not even on the arrestee's person. Nonetheless, the court held that some warrantless searches of cell phones might be permitted in an emergency when the government's interests are so compelling that a search would be reasonable. In other words, searches incident to an arrest generally allow for a search of any physical item. Even tactile inspection of a cell phone to ascertain that it doesn't contain razor blades or anything else that may be dangerous to a police officer, that is permitted. But you may not search, as law enforcement, you may not search digital contents of a cell phone because they contain the kind of private information and the vast amount of private information that you would find in a home. Therefore, you would need to get a warrant first. This was an important victory for Fourth Amendment rights. The Supreme Court here went against the courts of California. I remind you that David Leon Riley lost his case in every California court, but he won unanimously in the Supreme Court of the United States. This is an important example of vertical federalism at play, the relationship between the national government and the states. So we saw here that even a very liberal state like California, traditionally more sympathetic with the rights of the criminally accused than the vast majority of states, here, in this particular case, repeatedly ruled against the plaintiff, the criminally accused, David Leon Riley. And nevertheless, the Supreme Court, recognizing the tremendous importance of the expectation of privacy that pertains to digital data, ruled in favor of the defendant unanimously. A highly important, high-tech case pertaining to the Fourth Amendment. Thank you.